Ora, boa tarde a todos. É um prazer ter diante de nós o professor Dieter Grimm. Eu gostaria de saudar todos os presentes. I will speak first in Portuguese and after English. Eu gostaria de lugar também de saudar todos os membros da mesa, para o lado do professor Dieter Grimm, Presidente do Tribunal Constitucional, meu querido amigo de sempre, José João Abrantes, fomos assistentes do Natal do em Direito Constitucional, todos os melhores tempos da nossa vida, queria também saudar o Vice-Presidente do Tribunal Constitucional, o professor Almeida Ribeiro, e o professor Nogueira de Brito, também esteve da base da organização deste evento. E, portanto, agora passo a fazer algumas considerações preambulares. It is for me an honor, and as constitutionalist and coordinator of the Lisbon Public Law from this faculty, to welcome Professor Dieter Grimm to our annual lecture, addressing the very current and thought-provoking topic with our guest has long treated with dogmatic solidity. The constitutional identity of states links the relationship of tension with the law of the European Union. Professor Dieter Grimm, one of the most brilliant German constitutionalists, held a master degree in law from Harvard, a doctorate and habilitation at the University of Frankfurt, and also taught at the University of Bielefeld and the Humboldt University of Berlin. He succeeded Konrad Hesse as judge of the Constitutional Court. Professor Grimm is a friend of our faculty, having in recent years been a keynote speaker at the Luso-Brazilian Legal Forum, the largest juridical event of Portuguese-speaking countries, and it is therefore with great interest that we welcome him to address a very challenging concept. Since the Constitutional case, the then Court of Justice of the European Community has upheld the constitutional nature of the treaties and the supremacy of all European law over the constitution of member states. The Maastricht Treaty sought to alleviate the fears from some states regarding federal direction of the Union by adding a clause in which the Union would undertake to respect the national identity of the states without mentioning constitutional identity. This fear was not dispelled since the clause in question was interpreted by the European Court as a merely political programmatic declaration, a fact that did not prevent the constitutional courts of several states from putting forward in so-called dialogue with some European Court the respective clauses of constitutional identity. After the rejection of the Constitutional Treaty of the European Union, the Court of Justice has faced with some decision by the national constitutional courts with subtle judgments of the constitutionality of some European laws rooted in constitutional identity clauses. In a context of political fragility, the Treaty of Lisbon and the modifications of the Treaty of Union were harder than the Treaty of Maastricht and stated the obligation of the Union to respect not only national identity but also constitutional identity of the states in some sort of mingled law. Although the European Court adopted a restricted interpretation on the subject, the fact is that the constitutional courts of some member states invoked that clause in several proceedings before the same court. In Germany, based on consolidated case law reflected in its decision, for example, the Treaty of Lisbon, The Constitutional Court adopted a very more markedly sovereignist line in the Vice case, for example, regarding the limits of prevalence of European Union. Thus, and I quote, the court says, the democratic legitimation by the people of the public authority exercised in Germany belongs to the essential content of the principle of popular sovereignty and therefore forms part of the constitutional identity of the basic law protected in Article 79.3. Is therefore outside the scope of European integration. And then it declares the decision of the Europeans and online ultra-virus. I would also recall the argument of the Italian Constitutional Court in Carico 2 case, in which, after an incisive argument around the Italian constitutional identity, the European Court of Justice was forced to slightly back down to prevent its previous decision, and therefore applied. He avoided that the previous decision of the European Court could be declared by the Constitutional Italian Court also ultra-virus. Other European rules and court decisions were also declared ultra-virus. For example, the Czech Constitutional Court in the London case, the Danish Supreme Court in the Danish industry case, and the Hungarian Constitutional Court about the refugee quotas case. I would also remember some obiter dicta of the Spanish Constitutional Court, the case Meloni, when it was understood that the violation of the identity core of the Constitution by European law would give Spanish Constitutional Court the final word. If the rejection of the European Constitutional Treaty prevented establishment of a founding constitution in Europe, the fact is that, as seen last from the states, the European integrated federal project has not stopped. Under the pretext of overcoming each crisis, the binomial activism of the Commission and the European Court of Justice took new steps forward in the integrative process, which translates in expanding to its benefit more competences. It's happened with the sovereign debt crisis and with the pandemic crisis. Now, I guess, that the Russian invasion of Ukraine and the economic, strategic, and defensive crisis that follows after the American elections will accentuate this dynamic of collective political involvement in the areas of defense and foreign policy that are, I must remember, the core of the constitutional sovereignty of the states. In 2024, we published a collective work organized by Dr. Hirschel and Yannick Rosnet named Deciphering the Genome of Constitutionalism. On a dogmatic level, the book is disappointing, reflecting the likeness of a nominalistic constitutionalism, but its main objective was, in the doctrinal field, the deconstruction of the idea of constitutional identity. There are different kinds of discourses. Jacobson alludes to the fluidity of the concept. Fabrini and Sacco understand that constitutional identity would be a dangerous figure to be eliminated, as it was used by illiberal governments against democracy. A position not very far from Michael Rosenthal that alludes to the difficulty to define fitness. With more sophistication, Pietro Farraguna, in the line from Bogani, states that the identity was a barrier placed by several constitutional courts, notably the German one, against primacy of European legal order. Since the constitutional identity of the states was recognized in the treaties and cannot be eliminated, it up to the European Union, says Farraguna, to reaffirm its own constitutional identity based on the treaties that would take precedence over that one of the states. In defense of this European constitutional primacy, Union institutions should respond to sanctions in infringement proceedings against decisions that could declare European law ultra virus. But I dare to say, to sustain European constitutional identity, it would be necessary to prove on a legal and dogmatic level that Europe has a constitution, proof that was not accomplished. There is no precedent of constitution behind the states, and there are no constitution without constituted power, without people legitimizing the foundational intentional act, and without an absolute legal supremacy that could allow the Supreme Court, European Court, to declare null and void all the norms that contradict the same constitution. There is no constitution. European Court of Justice have crowned the treaties as a constitution, but the same court as any other court is not a constituted power. That power in democracy belongs to the sovereign people. And I must come to an end. And I think that on the eve of tectonic movements of an integrative and federalizing nature, I recall what Peter Grimm wrote when he underlined that constitutional courts are the only real counterpower to the avant-garde role of the Commission and the European Court, assuming a decisive role in custody of constitutional integrity of the states. We may not be able to account for that in certain countries, whose sometimes juridical institutions or jurisdictional institutions are perhaps ambiguous or even floaty about the subject. But not all the constitutional courts are equal, because some of them, fortunately, are being less people than others. Thank you very much.
Dear President of the Constitutional Court, dear Vice President, great honor that you took the time to attend my lecture and leave the otherwise. So I have dear Professor Morais, Professor Dieter, thank you for the invitation to this prestigious lecture. And as you already said, I always like to return to Lisbon. This is another occasion to do it. Has been developed already. What we are going to talk about now, it is the concept of constitutional identity. In Germany, this became a topic of political and of juridical discussion since the judgment of the German Constitutional Court on the Lisbon Treaty. Judgment was rendered in 2009, and the court in this decision dealt once again with the relationship between European law and national law, and its concomitant relationship between the European Court of Justice and national constitutional courts. And the court, it was already mentioned, the court reaffirmed its ultra virus doctrine. European law that does not have a basis in a competence referred by the member states will not be applicable in Germany. And the court added, the same is true for European law that is incompatible with the identity of the German constitution. Many commentators at that time said this is a new step, ultra virus. We knew ultra virus since the Maastricht decision. It's a new step, but this is not really true, because identity appeared already in the first important judgment that the German Constitutional Court rendered in matters European, namely the Solange number 1. This decision where the court said, many of you, well, everyone who's familiar with European law knows it, as long as there is no sufficient fundamental rights protection on the European level, the German court will review European laws and legal acts against the German Bill of Rights. And the reason that the court gave for this decision was that the basic structure of the Constitution, on which its identity is founded, is not open to change. And part of this basic structure is the protection of fundamental rights. So the consequence of that was that the primacy of European law, which the German court does not question in principle, but only in the margins. But what the consequence is, the primacy of European law ends where the identity of the German constitution begins. The Solange judgment found a lot of attention. However, the focus at that time was only on fundamental rights. It was not identity behind these fundamental rights. So when identity surfaced 35 years later, everybody started to talk about identity. I didn't know when it started in Portugal. Was it also the German case, or was it the Portuguese case? Whatever it was. So the question that I would like to treat in this lecture is, first, what does it mean, identity, constitutional identity? Then I would like to add that question that also came soon after the question, what is national constitutional identity? Isn't there already also something like a European constitutional identity? So my first question is, what does it mean? And I would like to distinguish three, I think, possible meanings of constitutional identity. The first one is very clear. No constitution is like the other. Every constitution, even if a constitution is borrowed from a different country, it's never totally. Each country has its own constitution and thereby its own constitutional identity. This is banal. This is rather a truism, but it is the precondition of comparative constitutional law. If all constitutions were identical, it would be possible to do the comparative constitutional law. But it's this type of identity is the basis of comparative constitutional law. But I would like to underline it's a descriptive meaning. It's not a normative meaning. It's a descriptive meaning. This means at the same time that it is not relevant for doctrinal purposes. You can interpret a constitution, a national constitution, without referring to constitutional identity. The second meaning is more precise, not banal. It means the core elements that determine the type of a constitution, the leading principles, the basic structure. The provisions without a constitution would no longer be the same, as opposed to the numerous provisions in constitution whose change or even whose abolition would leave the constitutional identity unaffected. So for Germany, for instance, such a element of the very core is human dignity, Article 1 of the Basic Law, and other elements as well. In this understanding, and a normative understanding, the meaning of identity as legal effects, it's doctrinally relevant. It's relevant for amendments of a constitution. Would amendments that change the identity be permitted or not? For Germany, the answer is rather easy. There is one article which is a supernorm in the Constitution, Article 79, Section 3, that describes the items of the Constitution that cannot be changed even by amendment. So for us, it is rather easy to define what is the identity of the German Constitution. You have these, and they are mostly in Article 1, dignity, and in Article 20, democracy, rule of law, etc. For other countries, without such a supernorm, it may be much more difficult to identify. At least it is more interpretation than just referring to one clause. So everything that is guaranteed in Article 79, Section 3 is derived immediately from the constituent power of the people. And as the court says, there is no possibility to change the basic structure. This can only be done by the constituent power, that is the people. Italy and India are two interesting countries who have no such clause. and have no limits to constitutional amendments, but they derive from the function of the Constitution. India, by the way, is a decision of slightly more than 1,000 pages. I've never seen any decision of a constitutional court, the Supreme Court, longer than this decision of the Indian court, but it states itself. The Indians are even more in the British tradition than the British themselves. In some cases, every judge writes. So I don't remember, I think there are 9 justices in the Indian Supreme Court, 9 opinions added, and then you have to read them all in order to know what the law is. Not easy, right away. But not only for the question of amendments, I think this type of second type of identity is also important for the interpretation of the Constitution. It guides the interpretation and it sets limits to interpretation. Interpretation that would not be compatible with the identity clause wouldn't be an acceptable interpretation. And now, number 3 of the possible meanings is more difficult to describe. Constitutional identity in the sense that people who live under a certain constitution regard this constitution as an expression of the popular will, and they regard it as an expression on how they would like political rule to be construed and social relations to be construed, how a good state should be ordered. And it has something to do with the conviction whether the people in general are convinced that they are living under a more or less good order, so that they identify themselves with this order. And this meaning, of course, is not a legal meaning. So the first one was a factual meaning, real. The second one is a legal. And here we are neither on the factual level nor on the legal level. It's only very loosely coupled with legal provisions of the court. It's rather the precondition of a successful constitution. I would say we are here on the symbolic level. So the symbolic meaning of constitutional identity. And when I said the first meaning is narrow, every country has its own constitutional identity, this is not true for the second and the third meaning. The core feature and the symbolic value, they are rather high-toned, they are not banal, they are inapt for everyday use, they are mostly latent or dormant, and usually there is no need to activate these types of constitutional identity as long as a constitution is not questioned or challenged. It's not by chance, then, that constitutional identity was invoked for the first time by the German court when the European Court of Justice had proclaimed primacy of European law over national law, including constitutional law that started in 1964, you could even say 1963, and thus posed a threat to the identity of the German basic law, a threat emanating from the then European community. So identity in the second meaning, in the legal meaning, I think, can be said to have a defensive function in the member states of the European Union. It erects barriers against the claims of European law absolute primacy. Internally, on the national level, it was not necessary to resort to identity because the threat to the identity of the German constitution that could come from amendments that could be dealt with Article 79(3). It was sufficient to protect the identity against amendments. But Article 79 binds the national organs of state, it does not bind the European Union. And so something stronger than Article 79(3) had to be found in order to protect the core of the Constitution against claims from foreign law. And this was found, and I think this is my explanation for the rule of constitutional identity. Here, this was furnished in constitutional identity. The links This type of identity, it links at the same time the legal and the symbolic level together. If a national constitution can no longer be perceived as an act of self-determination of a nation, but is conditioned by European law that may negatively affect the symbolic value of the constitution, which is importantly conditioned on its legal effectivity. So with this in mind, we can, I think, move on to the European level and ask the question, is there also something like a European constitutional identity? And if so, what is it composed of? And which function does it fulfill for the European Union? However, the question whether there is something like a European constitutional identity makes sense only, you mentioned already, if you have a constitution. And without that, it wouldn't be sensible to ask for a constitutional identity. So does it have one? The legal basis of the European Union are treaties, as everybody knows, concluded by sovereign states under international law. But these treaties fulfill a number of functions that, on the level of the member states, are fulfilled by the national constitutions. The Treaty of Rome established the then European Economic Community, later European Community, now European Union. It defines its purposes. It equips the Union with powers necessary to pursue the purpose, provides for the organs, defines their functions, determines the conditions under which the functions can be fulfilled, and as of later, it even contains a Bill of Rights. So insofar, the European treaties follow the constitutional pattern. And also the European law takes precedent over in treaty law, over secondary European law, and also in this respect, it shares the functions with national constitutions. So what distinguishes? What distinguishes the treaties that fulfill a number of functions of constitutions from the function in the sense of constitutions on the national level? First of all, not very important, the appearance, the outward appearance. It's much longer. Longer than even the longest constitution of a member state of the European Union. And I'm sure you know which constitution is the longest in the European Union. By far, left behind the Portuguese constitution, of course, by the European treaties. The explanation is, of course, that in 1957, when the European Economic Community was founded, the member states hadn't in mind drafting a constitution. They drafted an international treaty in which the rights and the duties of the member states on the one hand and the Union on the other hand should be described as precise as possible. And the consequence was that in these treaties, the vast number of provisions are not of a constitutional nature. Those the provisions for which we would find equivalence in national constitutions are rather small in number. The vast number of provisions would be ordinary law in the member states. So the difference between constitutional and ordinary law, which is crucial for constitutionalism, is leveled in the European Union, with detrimental consequences, by the way, for European democracy, and I think I may come back to that a little bit later. Secondly, and this is much more important in order to explain the difference between national constitutions and the European treaties. Secondly, constitutions are today, also you mentioned it already in your introduction, they are generally regarded as an act of self-determination of a nation, of a society, or of a people. Act of self-determination is to the form of its political existence and the modalities of political. This essential element of modern constitutionalism is missing in the European Union. The EU has no people. It has citizens, but it has no people. And it does not give itself a constitution, but it owes its constitution to the will of the member state. It receives its legal basis from them by way of agreement. The citizens are not involved in making, shaping, drafting, and adopting the constitutions. They are not even attributed to the people as the source of all power. So with regard to the existence and the purpose and the competence and so on, the European Union is not self-determined but hetero-determined. It is possible to assert that a constitution is acted, emerges by way of a treaty conclusion. This was, for instance, the case when the German Empire of 1871 was founded. Up to then, there was no Germany, there were only a number of German states, and they founded the German Empire by way of concluding a treaty. But with this treaty, at the same time it was concluded, they gave up the constituent power and handed it over to the German Empire. So it was transferred to the new political entity, and the nature of the treaty was thus consummated in the very moment of its conclusion. The new entity from that moment on was self-determined, and amendments didn't require a new treaty by the member states, but amendments were decided by the empire on itself. No, nothing like that happened into the European Union. The member states were never prepared to hand the constituent power over to the EU. Even in so-called constitutional treaty, it wouldn't have happened. It would have been a treaty named constitution, but not a constitution based on self-determination. But this is history. It failed, as you know, in 2004. Amendments to the European treaties need another international treaty that is ratified by all member states according to the rules of their constitution. So if we discuss this in terms of sovereignty, we can say that the member states transfer certain sovereign rights to the European Union, but they don't transfer sovereignty. The EU exercises public authority, but it is not sovereign. It's difficult for me to argue that a political entity, you know, there are concepts, shared sovereignty, divided sovereignty. It's difficult for me to accept that a political entity that depends with regard to all things, exists, purposes, etc., who provides, I cannot find sovereignty. So my conclusion is that if one looks for the basis of a European constitutional identity, it can only be the treaties. There's nothing else. And I don't mind to call the treaties a European constitution, but I find it very important to keep the difference in mind. So the other thing is not the most important thing, but the difference in subject matter is the most important thing. So if we call the European treaties a constitution of Europe, we always have to be in mind that it is more a metaphorical speech. It's a very thin notion of constitutionalism, with democracy, democratic origin as the integral part of modern constitutionalism left out. So among the three meanings of constitutional identity that I presented, the symbolic meaning is directly linked to the democratic element. Are the treaties, this is the question, are the treaties, in spite of the fundamental difference with a constitution, are they capable of serving as a basis of a specific European constitutional identity? And another question, why would the European Union need such an identity? This is the question which I will turn to now. Let's take a look to the treaties also mentioned already by you. Identity is mentioned, but not in connection with the European Union. It is mentioned in connection with the member states. The national identity of the member states should be respected. And then it is said that the national identity can be found in the constitutional structure of the member states. There is a reference to the member states' constitutions. So the constitutional identity comes in insofar as the national identity is declared as finding expression in the fundamental political and constitutional structure. Of course, the silence of the European treaties regarding a European identity does not mean that it doesn't have one. I don't know many constitutions, state constitutions, that mention identity. Nevertheless, they have an identity. This could, of course, be the case in Europe as well. Well, for me, there is no principal obstacle to speak of a European constitutional identity to the extent that the treaties may be called a constitution. If their quasi-constitutional character is accepted, notwithstanding that it is only a functional constitutionalism, there can hardly be a doubt that something like a European constitutional identity exists. Certainly, in the first sense, every political entity has its own constitution. Certainly, in the second sense, in the legal sense. Still, not an identity of the constitutional, of the substance of a constitutional identity. Treaties draw their identity in this sense mainly from the fact that they are not a constitution in the sense of, let's say, constitutions. What identity, if we say there is basically, there can be an identity, what is the identity is not the same identity as that of the member states. It's rather, it's their supranational character, which is an important facet of the European identity. Among the core elements of the treaties understood as a functional constitution, a European public authority is not entrusted to the EU by a European people, but by the states that preserve their sovereignty and transfer a number of powers. This finds an expression in the principle of competence. The member states determine which competence the EU has, not the other way around, and it is determined by the principle of conferral. The EU has only those competences that have been transferred. And it also finds an expression in the European Council. Well, I think substantially, these were all common elements. In terms of substance, we should count the four economic freedoms among the core of the European constitutional identity. And then the Lisbon Treaty, of course, added the values of Article 2 of the treaty. And so I think if we put these together, we more or less have what a constitutional identity of the European Union could be. But we would not reduce it to the values. I think this is what the European Court of Justice does. It reduces it to the values, but one should take these organizational structures in account as well. So, while the supranational elements distinguish the legal foundations of the EU from the constitution of the member states, they share the identity that flows from values and from rights. And they owe each other mutual respect. The EU respect to the member states respect to the values of the EU. But neither values nor the supranational character of the European Union are usually discussed in European law in terms of European constitutional identity. And if one asks why, I would like to remember you of the function that identity develops on the national level. That it develops defensive functions, I say, against the European law. And it seems that until recently, at least, the treaties were not under a similar threat like the national constitutions are from the side of the European Union. As far as the member states are concerned, every expansion of the transfer powers by way of treaty interpretation limits the scope and the scope and the impact of the national constitution, but the EU is much less affected from the side of the member states. So that means yes, the Benel constitutional identity, yes, the legal identity, but different from the identity of the state. So what remains is the symbolic identity. Does the European Union have a symbolic identity? Constitutionalism in the symbolic sense. Again, this does not refer to the legal character of the Constitution, but to its capability to generate an identification of European citizens with the EU. Yet, in terms of acceptance, I think one can still say that, maybe even more than some years before. In terms of acceptance by the citizens, the European Union lags far behind the majority of member state. So symbolic identity is what the European Union most needs, as the other types of sovereignty would need in order to be more accepted or internalized by the people. It need symbolic identity. What explains the difference with regard to symbolic identity? I think one should take into account that states are the political form of an existence of a people, or a nation, or a society. The citizens belong to their state, regardless of all differences and all conflicts within the state. They are united by belonging to a state. In Germany, there is a term, interesting term. The state is a Schicksalsgemeinschaft, a community of fate. The European Union is not perceived as a community of fate. It's more or less an artificial identity from most states with limited tasks, which has up to now not been able to generate this sense of belonging that we have in most of the member states. The states may be criticized by their citizens. The performance of the rulers may be contested. Even the political system of a country may be questioned, but it leaves the right of existence to that state in place. Even people who reject their government or attempt to change the political system in the system of the state, very often deeply affected to their country. The EU, to the contrary, is constantly confronted with doubts about its necessity. A growing number of citizens sense the European Union as a threat to national identity. Everywhere, nationalism is regaining the scene, Germany included. But even where the existence and the usefulness of the EU is accepted, the emotional relationship of citizens with the EU is certainly lower as the emotional relationship of citizens of the state with their states. So the ever closer union lacks the popular basis to a large extent. Could an increase of symbolic constitutional identity help to solve the legitimacy acceptance problem of the European Union? And why is that perceived as a problem today when it did not bother people in earlier years of the existence of the EU? I think the turning point was the point when the people noticed that the EU was no longer a common market, no longer only a common market, with a lot of advantages for every country. Portugal profited a lot of the European Union, but when people became aware it's not only an economic endeavor, it is a political project that affects people's life more and more intensively, yet without an express will of the people. Rather, whether citizens were asked to endorse the program of integration, as with the Constitutional Treaty in 2004, it was rejected by the people. The immense progress, but I don't want to leave any doubts, the immense progress of European integration, which I endorse. I'm not and in no way opposed to the European Union. I think it's a terrible loss we did not have it. But one has to understand that this immense progress was made by stealth, to say, to a large extent by the jurisprudence of the European Court of Justice, so to say, incrementally, in a non-political mode, without a public discussion. And I add, this stealth, this secret way, was even a condition of the big progress that was made. But the more the integration advanced, the more this stealth became a problem. And the legitimacy resources that were sufficient for the common market are no longer sufficient for a political entity, European Union. So these are some of the reasons for the identity discussion in Europe, whereas the discussion of identity in the member states is prompted by the increased rift in the societies of the member states, and then, of course, by the threat to the identity that emanates from the European Union. So my question, and this will be the last part of the lecture, are there sources for a European constitutional identity? In particular, are there chances that the treaties, or perhaps the European Constitution in the true full sense of the term, like in the member states, are there chances that they close the gap between the states and the European Union? In order to answer that question, I turn for a moment to the states and ask what their identity, the state's identity, is based on. Mostly still on the nation. The uniqueness of the nation, even the otherness of the nation, sometimes even the assumed superiority of the old nation vis-à-vis other nations. The great periods in history of a nation, military victories, the persistence in existential crisis, the cultural heritage, the discoverers and inventors that the nation has brought forth. Football even can be basis for national identity. Constitutions, usually not. That the national identity is based on the constitution of the country is, in my view, rather rare. Constitutions are expected to function legally, and if they fulfill their function, this is fine, and they are accepted as such, but they are usually not taken as the basis of their identity. But under favorable conditions, it is possible, it may happen, that constitutions serve as basis of national identity when they exceed their regulatory function and fulfill also the symbolic functions. Then it may happen. And of course, the country for which we would all assume that the identity is to a large extent based, or I should better say was now based, is the United States of America, a country which emerged from a triumphant revolution for which the Declaration of Independence stands. And it was established as a state by the Constitution of 1787. Before that, there was no independent history of the US, no independent culture, no independent faith on which identity could be built, which was composed of immigrants from very different nations and cultures. The Constitution was what they shared and where they were proud of. And it was the first modern Constitution at all. And it promised them a better life than it had been in the countries of origin. Another example is Germany, my own country. The identity of the Federal Republic, I should say the old Federal Republic before unification of Germany. The old Federal Republic was based to a large extent on the basic law, on the Constitution. Yet different from the US, there was not a triumph at the beginning, but there was a national catastrophe at the beginning that had destroyed all old sources. This is important. All old sources of national identity had been destroyed. The nation was divided. discredited by exaggerated nationalism. History was loaded with the Holocaust. Culture was needed at the last remaining bond around the two parts of Germany. So there was a gap in national identity, and my thesis is that in Germany, the constitution managed to jump into this gap, and it symbolized the rise, after a deep fall, the rise into the circle of civilized nations, so to say, and it was regarded as superior to what happened in East Germany, which also had a constitution which legally didn't matter it. However, I think this success wouldn't have been possible without the German Constitutional Court that made the relevance of the Constitution almost every day visible to the general public. So that in the end, something very strange developed, which I think doesn't have a parallel in other nations, the version of constitutional patriotism in Germany. And it's not usual that patriotism is linked to constitution, but it was the matter at that time. Yet, post-Second World War conditions in Germany are so unique that they do not serve as a model for European identity. But perhaps the United States, this is often used as an example that something like a constitutional identity of the European Union should be possible. And of course, there are parallels. The United States and Europe share the multi-ethnic and multicultural citizenry. The difference is, and I think it's an important difference, the difference is the European people do not leave their countries. And they are not ready to a new start in a totally different environment. They stay in their old environment. They remain part of their tradition. They remain part of their culture, their education, their political system, the national discourse. Of course, there's free movement within the European Union. Most people are not keen, except for occasions, perhaps, to live in a different country. Allegiance is more or less a matter of national belonging in Europe. So, which conclusions to be drawn from this analysis for European identity? I would say that almost all three conditions that contributed to the symbolic effect of state constitutions are missing on the European level. It's true there wouldn't have been European integration without the devastating consequences of World War II, but World War II is meanwhile long ago, and peace within the European Union, among the European Union states, is, I think, not attributed to the existence of the European Union. If you think the European Union away, the immediate consequence wouldn't be wars again among the member states of the European Union. What else could it be? I think economic success, which certainly is an asset of European integration. Economic success is not valid for an emotional basis. It's served other purposes. Moreover, the treaties are not prone to acquire a more symbolic function. They are not conceived as a constitution. They have little appeal to emotions. They are very technical law, detailed rules for the common market, difficult to perceive them as a constitution. The sheer amount of the provisions is different. Vast majority are not of, as I said, not of a constitutional nature. This difference, ordinary law, constitutional law, is to a large extent leveled in the EU. Constitutional law contains the fundamental principles, the basic structure, the premises for political decision-making, but they leave the constitutions, leave the decision-making themselves to the democratic process. That means to the preference of those political groups who obtain a majority in the election. Whereas in the EU, these decisions, these political decisions, are to a large extent already taken in the treaties, and this explains the volume of the treaties. This is not a matter of legal aesthetics. this is a matter of democracy. This is the democracy problem of the European Union, in my understanding. All these rules that are not rules of a constitutional nature, nevertheless participate in the primacy of constitutional law. That's to say, they are not open to the democratic process. They are all withdrawn from the democratic process. And this means at the same time that the accent is shifted from the political institutions to the judicial institutions. The European Court of Justice can frame the common markets according to its own understanding of the common markets without needing the member states. The member states are sidelined for everything that is regulated on treaty basis, and the member states don't have a possibility. If they do not agree, they don't have a possibility to change things. Why not? The answer is constitutionalization of the treaties. The only way to do it would be a constitutional amendment, a treaty amendment, but a treaty amendment would never be available for question of redirecting a line of jurisprudence of a court. I think that this shows that the so-called functional constitution of the EU in its present state is not the possible basis of a symbolic value. Then, I think my last question, would it be helpful to revive, to revitalize the idea of a true European constitution, let's just say a constitution that has its constituent power in a European people? Would that help? What would it require? It would, in the first place, require that one takes all the provisions out of the two treaties that are not of a constitutional nature and downgrades them, not give them back to the member states, but downgrade them to European secondary law, so that only the provisions of a constitutional nature remain on treaty level. And this means that one opens the rest again to political decisions and not only to judicial decisions. And it would secondly, and equally important, it would be that one would have to root such a constitution in the self-determination of the European citizens. After a long history of European integration without participation of the citizens, I think this would be the precondition of a symbolic effect of a European constitution. But before deciding that this would be the right thing to do, I think one should ask for the consequences, and the consequences should be quite clear. As soon as you transform the treaties from treaties under international law into a constitution in the full sense of the term, you will turn and transform the European Union into a state, whether you like it or not. It's the inevitable consequence of adopting a constitution in the full sense with all the democratic elements included, that then the European Union has become a state. And then the question is a state, a European state, desirable or not? And the main question, of course, is, does the European Union, when more or less disconnected from the states, have the sufficient resources? Right up to now, the majority of democratic resources come to the European Union via the Council. Then these flow of legitimacy would be cut. The legitimacy would come from the European Parliament, elected by the citizens. It's not that long ago that we had European elections, and I think what is true for Germany will probably be true for Portugal as well. There are 27 added national elections. Only national parties compete. They compete with the national program. The result is measured. What would it have meant if it had been the national election? And then there are these national parties in the European Parliament. How many? More than 200. More than 200 parties, which do not play any role in the European Parliament. The role play the 7 factions to which these parties of a similar program resemble, but we have the strange situation that those whom we can pay, well, for the national parties, have no say in the parliament, and those who have a say, these factions, we cannot vote, and they are not in contact with any society in the national states. So a lot of things would have to be changed, and still my doubt remains whether it would be possible to accumulate this degree of democratic legitimacy, of adherence, of symbolic value that states, to a certain extent, not all in the same way, have in the European Union, even if we transfer it to the state, because the democratic substance of a state is not decided only on the institutional level, it's more decided on the societal level, so that the organs, the organizations, the state are embedded in a continuing, ongoing public discourse and are in constant contact with society, and therefore the preconditions in Europe are still much weaker than they are the basis of the nation states. So this is my facet, and it was a little bit too long, maybe. I admire you for your patience.
Thank you very much, Professor. Please, congratulations on your lecture. And I will give the floor to Professor Almeida Ribeiro for a comment. We have 10 minutes, more or less.
Thank you. It's an honor and a pleasure to be here. To see you again. Professor Grimm is a great champion of constitutional law in Europe. Both in a scholarly capacity and as a former judge of the Constitutional Court. When I teach fundamental rights to my students, because like you, I'm both a judge and a professor, I always teach them this very famous case of the case. And that case has a remarkable dissent drafted by you. A dissent is a rather common feature of Portuguese constitutional practice, but it's quite unusual in Germany. German constitutional judges are extremely parsimonious in the exercise of their power to dissent, but that is a very remarkable and I always tell my critics that they should be very careful. And it's really an honor to hear you. Your lecture is, I wasn't told before what would be the topic of your lecture, except in very vague terms. And when I realized we're going to talk about constitutional identity, my immediate thought was that it's such an obscure topic. The reason is that everyone speaks about constitutional identity, but it's very difficult to figure out what people really are talking about. I think part of the reason is that constitutional identity is both part of the vocabulary of constitutional theory, so it serves a speculative function, but it's also part of the practical vocabulary of constitutional law, and it has become a weapon in the armory of institutional activists constantly deployed, named by apex courts, to protect whatever they see as something worthy of protection in their jurisdictions. And the other reason why it's a complicated topic is because the concept of identity is a very controversial and difficult concept also in general philosophy. And as I was listening to you, I was thinking that there's a distinction to be drawn, which is often unclear when we speak about constitutional identity, between two notions of identity. For example, there's a pretty famous essay by Paul Ricoeur on this. One is identity as the metaphysical notion of sameness. As you know, there was a big fire which destroyed part of Notre Dame Cathedral a couple of years ago, and the French have rebuilt the cathedral. There's a lot of new material in the refurbished cathedral. It's still the same thing. So that's very much part of what we discuss when we ask, for instance, if the Portuguese constitution, which has been amended 7 times, but has been heavily amended, particularly 1982 and 1989, is it the same constitution? if a foreigner, an educated foreigner like yourself, reads the original version of the Portuguese Constitution and the current version, you might think that the change is so substantial that it is unlikely to be true that the identity of the Constitution was preserved, if by identity we say it's true. But then there's a different notion of identity, which is far more prominent in moral and political philosophy, which is identity as selfhood. So not about the whatness of things, but about the who-ness of things. What are the conditions for a subject or a self to remain constant across a span of time? For example, I suppose that the Portuguese understand themselves to be a collective entity capable of acting. And moreover, to identify themselves with, say, the Portuguese in the 12th century, even though it's perfectly obvious that the Portuguese nowadays are vastly different, thereby metaphysically altogether another with respect to those people that were in this particular geographic circumscription in the 12th century. I think that it's often unclear what people are talking about when they talk about constitutional identity. Then another issue is that sometimes what we ask is what makes a particular constitution the same constitution, right? What is the basic structure, say, of the German constitution? But sometimes the question is a question you ask about the European Union, and that's the one I want to focus on because I only have 4 or 5 minutes. And that is, what are the distinctive features of constitutions? That is, what are the features required for a legal system to possess a constitution? So the question we asked is the often posed question of whether the European Union has a constitution. I must confess to you that I find this question to be a question of the same nature as the old question of whether international law is good law. I suppose the answer to that question is that sure, international law possesses many features of what we take to be the paradigm of law, which would be domestic or municipal law, but it does not possess the full range of features that is characteristic of municipal or domestic law. So I think it's the same thing about the European Union. So one thing is fairly clear, the European Union is not a state. So if you stipulate, as Professor Moraes did, that a constitution is particular to a legal and political form, which is the state, then I think it's quite clear that the European Union possesses no constitution. And the reason for this is that, of course, there are a number of ways in which we can define a state, but if we take the, say, standard Weberian definition of a state, that a state involves the monopoly of legitimate violence, the answer is obviously that the European Union commands no means of enforcing its own norms, right? In 1957, when the Treaty of Rome was signed, the governor of Arkansas refused, was a racist, to enforce Brown versus Board of Education. There were these black children that were trying to access a high school, which according to the Supreme Court had been desegregated, and there was a barrier by locals who did not want their children who were white to coexist at the school with black children, and the governor of Arkansas was on their side and thereby refused to deploy police force to enforce the constitutional right of those children to attend the school. And President Eisenhower sent the 101st Airborne Division to Little Rock, Arkansas to enforce the judgment. And obviously the European Union is incapable of doing that. But in many ways, and this is the remarkable thing, EU law functions like the law of a federal state, in spite of the fact that the European Union is not a state. And that is because it has many constitutional or quasi-constitutional features. I think the European Union is a little bit like the Catholic Church in the Middle Ages. At the time of the famous controversy over investiture, so the question of whether is it the emperor's prerogative or the pope's prerogative to appoint bishops, right? And the emperor had the armies, the pope had no army whatsoever. But in the late 18th century, after the emperor was excommunicated and the pope called German princes, released from your duties to obey the emperor. The emperor came all the way to Canossa Castle in order to throw himself at the knees of the Pope, because the spiritual power of the Pope, even though it was not backed by any secular arm, was sufficiently threatening given the belief system that was socially effective at the time. I think the same thing with the European Union. The Court of Justice has quite remarkably persuaded an enormous number of domestic legal actors, including judges and particularly apex judges, that it would be something akin to the catastrophe of excommunication in the Middle Ages for them not to treat EU law as if it were federal law with all the distinctive features of federal law in a federal constitutional state. And let me highlight just a few, and then I'll finish. That first, there is the issue of direct effect, of course. And direct effect means essentially, in our vocabulary as constitutional lawyers, that EU law claims to be directly applicable, not in need of any normative mediation through the legal systems of the member states. Now, it's true that international law occasionally makes claims that this work, but this is exceptional and for the most part ineffective. But in the case of EU law, this has been directly effective. So EU law has claimed a feature that is distinctive of post-World War II European constitutions like the German and the Portuguese, when they say fundamental rights are directly applicable, and thereby there is no need for statutory provisions for these rights to be effective. And then primacy, which also exists in international law in the sense that it is no excuse for a state to invoke its own constitutional law to evade international obligations. But international law has no means of instructing a domestic judge to set aside a national norm and to apply an international norm. And of course, the Court of Justice has done that. And then on top of that, we have the fact that the German Constitutional Court and the Italian Constitutional Court have made the European Union incorporate substantive constitutional standards into EU law as a prerequisite for direct effect and primacy. And thereby, we've had fundamental rights for a long time. Of course, now we have the Charter. And we have the fact that in a very defective or flawed way, the institutional architecture of the European Union does resemble in many ways that of a federal state, in the sense that we have three branches of government. There is a bicameral legislature. Of course, the Council of the European Union is a very strange body. There is a predominance of national executives in the legislative process at the EU level, but it does have many features that are characteristic of federal systems. Then, of course, there's a symbolic aspect that is missing, as you said. But we've had examples historically of federations that were brought into existence either by treaty. I mean, it's arguable that the United States Constitution is a constitution in the sense in which you define a constitution as an expression of collective self-determination. The representatives of the states in Philadelphia were mandated to change the articles of the Confederation, which was in modern language an international organization. They obviously violated their powers and they decided to draft a constitution. But then this was ratified by the states. It's not entirely clear if the United States Constitution in its origins, definitely not after the Civil War, wasn't really an example of a constitutional system that was originated by conventionalist or internationalist mechanisms. And then, of course, in the 19th century, we have many examples of constitutions that were gifts by absolute monarchs to the people. So not at all expressions of collective self-determination, except retrospectively, a good example would be, of course, the French Charter of 1814. I suppose many examples in Germany for the Constitution of 1871 of princes that decided to give as an expression of their sovereign charity a constitution to the people, and then to, it's true, limit their own power by giving that constitution. But the point is that so different from the European Union? So we have international treaties. These international treaties regulate the amendment of themselves, which is extremely odd from an internationalist perspective. So the treaties regulate the process of their own amendment in a way, saying that the rules for their amendment are not the rules of the Vienna Convention and General International Law, they are the rules that the treaty itself establishes, very much like, say, the King of Portugal in 1826 saying, here is a constitution, from now on my power is a power that is constituted by the constitution which I've given you as an exercise of my absolute pouvoir constituant. So what do I want to say by all of this? I think to the question of whether the European Union has a constitution, the answer that I would give is that yes and no. And to finish it, this reminds me of a conference that was given once by a famous American philosopher called Sidney Morgenbesser, who was apparently asked in the 1960s whether he agreed with Chairman Mao when Chairman Mao said that some propositions are neither true nor false because the people is above formal logic. And he was asked, do you agree with that, Professor Morgenbesser? And he said yes and no.
Thank you very much. And now I will give the floor to Professor Deliberation for the final comments.
Thank you so much. Lucky for me, Professor Dieter Grimm doesn't give no presentation to the audience, so I would like to be brief. Time is running. I have three comments for Professor Dieter Grimm. My first comment is related to the question of possible European symbolic identity. In a paper published a couple of years ago, Professor Grimm said that the beginnings of the European Union are not marked by a constitutional moment. By this, I think he had in mind the American constitutionalist Bruce Ackerman, who argues that major changes in constitutional law can happen outside formal amendment processes when there are unusually high levels of sustained popular attention to questions of constitutional significance. So he also acknowledged that European integration would be hardly possible without the devastating consequences of World War II. But as he said, even if one imagines Europe without the European Union, the consequence is not war. Well, I agree if by war we mean a war between European member states. But what about the war with a third party? Of course, I have in mind the Russian Federation. So, my first comment would be, does this possibility affect the question of European symbolic identity? My second comment is related to the famous judgment of the German Constitutional Court from May 2020 on the public sector asset purchase program, which was declared ultra vires by the Constitutional Court. Well, I will discuss this decision. My concern is about what happened next after the decision. So, as Professor Grimm has demonstrated in an article on his judgment, in case a constitutional court finds the Court of Justice of the European Union to have acted beyond its powers, the result is that there are two conflicting judgments on the same issue, and so Professor Grimm says it falls to politicians to decide the situation. But what have the politicians done in this case? Well, the European Commission has filed an infringement proceedings against Germany, but these procedures were closed because in the response of Germany to the formal notice, there were given assurance that basically no further ultra-virus judgment on the part of the Constitutional Court. So it seems that politicians have declined to any possible mandate they have to sort things out. And at the same time, of course, they have disavowed the ruling of the Constitutional Court. But on the other hand, they think, I guess, that the best way to handle any conflict between jurisdictions is to leave it to the courts, since politicians don't get involved. So I would like your comment on this event subsequent to the judgment.
You said three. I know that only two. What was number three?
No, number three. I come to it now. My third comment.
Yeah. Okay. Comment. I was afraid I missed one.
No. My third comment is the recent German constitutional reform of the end of the last years, more or less a month after Trump elected, and I think this was not totally occasional. And so this reform, of course, basically it said that the regime of the function of the Constitutional Court, which was ordinary law, was put in the Constitution. And so the objective, of course, was to make it resilient against changes of ordinary law. Any change in the function of the court should be approved by a constitutional reform requiring 2/3 of the MPs, German MPs. We can all understand the background of this reform, can be summarized in a few words: the rising of the liberal democracy. But I wonder, this is not this German answer, it's not a kind of constitutional patriotism, as you say, that is the idea that political attachment ought to center on the norms, the values, the procedures of law, and this is not also the case in the European Union. So, have not Germans invented the kind of symbolic identity that could assist the European Union? This will be my last point. Thank you so much for your excellent presentation.
Now I think it's more really to answer your comments.
I like what you said, and I know disagreement with it. Very nice that you mentioned my dissent in the Elters case. I wrote 2 dissenting opinions in 12.5 years, but this one is well known even outside Germany. So I can find myself in order to be brief to the questions that were directly addressed to me by Professor Brito. I think that the Ukrainian war has the potential of strengthening the European Union because many member states will feel that there is an unexpected threat that comes closer and closer. So you are the farthest away geographically from this threat. And I think Putin, neither Trump has announced that he wants to enact Portugal, nor has Putin declared any vision of that sort. But for many member states of the European Union, this is a very close danger. So what will happen? I think that a number of people who are not deeply in favor of European integration will realize that it is a necessity. And I think that the willingness to spend money on defense will increase, and there will be something, not a European army, but there is certainly a stronger cooperation in terms of military support. But I don't see it changes the lacking preconditions of the European constitutional identity. So I think it will have may have stabilizing effect in Europe and at a time where many countries rather going away from the European Union. Number two, politics. But I said in this case, it depends on politicians what will happen. I wanted to say that there is no legal remedy because both courts, the national courts and the European Court of Justice, emanate from a principle, and from that principle on, they operate logically. And the two principles are not reconcilable. The European Union has no instrument in order to do that. So it was the turn of the politicians, but what did they do? They started an infringement procedure, and Germany answered. Because I tend to say it was a somewhat ridiculous answer. The court enumerated out of the jurisprudence of the German Constitutional Court those sentences the court said that he is friendly towards Europe. And then the German government said, and we will do everything which is within our power to guarantee that the primacy of European law will be upheld. But in their power is not to redirect the Constitutional Court. So it was now again, so this was the reaction of German politics. Infringement, political reaction from Europe, German, and then it was again the reaction of the European Commission. The European Commission said, oh fine, they say they will do everything. So it doesn't undermine by saying that the politicians are stubborn. And the last are these constitutional reforms in Germany. They are not caused by Trump, they are caused by the victories of the new extreme right party, AfD, in the East, in the three German elections in the East German countries, where in one state they became the biggest party, and in the others they had tremendous success. The basic law doesn't say very much about the Constitutional Court. They left that to the legislature, and the first Bundestag, after nearly 2 years, to write and enact the statute on the Constitutional Court. But that means that very important conditions for constitutional adjudication are on statutory level and not on constitutional level. And then the field, of course, was, should these parties get a majority, it will certainly try to get hold of the Constitutional Court, as we see it in many states. And so the idea was to elevate what is on the statutory level to the constitutional level. Only they decided not to do this for the most important part. The most important part, I think, which explains a lot of the success of the German Constitutional Court, is that the judges are elected with a 2/3 majority. And never got any political party even close to a 2/3 majority. So always majority and opposition had to find an agreement which prevented strong partisan people to enter the court and put the emphasis more on the professional capacity of judges. And the Christian Democrats were opposed to elevating this element, which I say is the precondition that all the others were at constitutional level. So it's now possible. Of course, the rule stands, but on statutory level, 2/3 majority. So simple majority could decide from now on, we elect constitutional judges with a simple majority. And this would take some time because we have a 12-year mandate for the judges. It would take some time, but then you would have a loyal court to whoever the majority is. So the terrible mistake, and I hope it will not materialize, so to say, you connected it with constitutional patriotism. I didn't see the connection?
No, the idea was in fact the idea that there is in Germany a strong feeling about norms and constitutional norms and
and so with that. If we ask the question in a very rough way, in order to solve conflicts, do you trust more on democracy or do you trust more on the rule of law? I would say the Germans trust more on the rule of law. The Americans trust more on democracy. There is a strong belief in the power of the law, and this is, I think, also why Germany in negotiations put so much emphasis on the law, which is some other member states of much less importance. So, guys, you are right.
So, thank you very much. It was very challenging. I think that our constitutional meetings was really one of the best one. And thank you very much for presenting. I asked the president of the board to give the final words.
Thank you, Professor Grimm. It was an excellent conference, and also the comments of Professor Carlos Blanco de Morais, Professor Almeida Ribeiro, and Professor Miguel Nogueira de Brito, and also this debate. It was really very interesting. It was an honor and a great pleasure to hear you and to learn with you. Thank you, Professor. It was really excellent.
Thank you so much.
Thank you.